Hello and welcome to Courts This Week by LiveLaw. This is Advocate Ostika Das and I'm Debojit here with a track of the most important legal developments shaping rights, accountability and the justice system. From the Supreme Court to high courts across the country. So without any further ado, let's begin. Our first story today is about judicial independence and how fragile it can become when judges are targeted for the orders they pass. In a rare and serious move, 56 former judges have publicly condemned an impeachment motion against Madras High Court Judge Justice G.R. Swaminathan. Ostika, what's the controversy here?
So this all began with a fairly local dispute in Madurai. The case involved devotees wanting to light the Kartikai Deepam at a stone lamp pillar called the Deepathun on the Thiruparantundram hill next to a dargah. Justice Swaminathan had earlier allowed this, making it clear that lighting the lamp did not interfere with anyone else's religious rights. But the problem was, the authorities did not implement the order. So a contempt petition came up before the court and Justice Swaminathan took a very firm stand. He said that if the administration was unwilling to act, the devotees themselves could go ahead and light the lamp with CISF protection as a way of enforcing the rule of law.
I'm guessing that this is the order that triggered a political storm.
Yes, exactly. So soon after this order, which by the way has now been challenged in an appeal, MPs from the DMK and some opposition parties moved an impeachment motion in Parliament. They accused Justice Swaminathan of misconduct, bias, and of acting against secular principles, essentially arguing that his order reflected a particular ideology. That's what prompted the strong response from the former judges. In their statement, they said that this was nothing short of intimidation, that judges cannot be threatened with impeachment simply because their decisions are controversial or politically inconvenient for some.
So this isn't just about one temple dispute.
Not at all. This has now become a much bigger conversation about judicial independence. The concern is simple. If every unpopular judgment is met with threats of removal, judges will start thinking twice before deciding sensitive cases. And this isn't happening in isolation.
You're right. For instance, just days ago, the Chief Justice of India said he would not be browbeaten by social media criticism while rejecting a plea to transfer a rape trial. This comment itself came after backlash over his observations in the Rohingya refugee case, which led to open letters, first criticizing him and then others defending him.
Another example from this week alone is former Supreme Court Judge Justice Madan Lokur's disclosure that when he was part of the Supreme Court Collegium, the government repeatedly pushed to transfer Justice S. Muralidhar, not for administrative reasons, but because it was unhappy with his judgments.
And when we talk about retaliation or pressure on judges, sometimes it isn't even subtle. Take, for instance, Advocate Rakesh, who had earlier attempted to throw a shoe at former Chief Justice of India, B.R. Gavai, inside the Supreme Court. He was reportedly upset over the former Chief Justice's remarks about a Vishnu temple and was back in the news this week for being attacked with slippers inside Delhi's Karkaduma court complex.
So when you put all of this together, it's clear this moment is bigger than one judge or one order. At its core, this is about whether judges in India can decide cases, especially politically or socially sensitive ones, without fear of different kinds of retaliation, be it impeachment motions, public vilification, or actual assault attempts. And that question goes to the heart of judicial independence and therefore the rule of law itself.
Next, the focus is inward, on the legal profession itself. The court has ordered 30% reservation for women in the state bar councils. Ostika, what did the court actually say here?
This is a big one, Devojit. The Supreme Court has directed that 30% of seats in state bar councils must go to women. For this year, it's split like this: 20% through elections and 10% through co-option to make sure women are actually represented even if election numbers fall short. And for those who are unaware about what co-option means, if elections don't bring in enough women, co-option allows the bar council to step in and add women members directly.
So what compelled the court to intervene at this point?
Two women lawyers, Yogamaya MG and Shaila Chaudhary, filed petitions in the Supreme Court seeking women's reservation in bar councils. And the Supreme Court happened to agree with the points they were making. Despite women making up a growing part of the bar, their presence in bar councils is shockingly low. These councils control enrollment, discipline, and policy for all lawyers under their jurisdiction. The court said that if women are missing there, that is in the bar councils, equality in the profession becomes meaningless, and waiting for things to naturally improve hasn't worked for decades. That's why the Supreme Court decided that if there are social and systemic barriers preventing women from getting a seat at the table, will make sure that they have not one but several.
In another big win for women, we have a really important ruling under the POSH Act from the Supreme Court. So what can you tell us about this, Ostika?
So the Supreme Court has clarified that a woman can complain to the ICC of her own workplace even if the person accused works somewhere else. She doesn't have to chase the other person's department just to get her complaint heard under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013.
And that was exactly what the accused was arguing, right?
Yes. So to give a brief background, the complainant here was an IAS officer attached with the Food and Public Distribution Department. She alleged workplace harassment by an employee of the Central Board of Direct Taxes under the Department of Revenue and filed a POSH complaint with her own department's ICC. The accused challenged that ICC's authority all the way from the Central Administrative Tribunal to the Delhi High Court and then finally the Supreme Court, with every forum rejecting his claim. At the heart of his contention was that I don't work in her department, so her ICC has no power over me. The courts shut that down. The Supreme Court in the appeal said that reading the law that narrowly would completely defeat the purpose of the POSH Act. Harassment often happens across departments, meetings, shared offices, official visits. If women had to approach the accused person's ICC every time, it would make the law inaccessible and intimidating. And therefore, this very important clarification was issued.
Thanks, Ostika. It's clear that this ruling removes a major technical hurdle and makes sure women can seek redress where they actually work, quickly, safely, and without procedural roadblocks. Next up, a big Supreme Court ruling that will matter to tenants and government bodies alike. The court has clarified when rent control laws apply and when they don't. Ostika, what's the crux of this decision here?
In simple terms, the Supreme Court has said this. Once a property becomes public premises, say it belongs to LIC or a public sector body, and the tenancy is legally terminated, the occupant can't hide behind state rent control laws anymore. Eviction will then happen under the Public Premises Act, which has a much faster summary process. In holding this, the court has overruled a 2014 judgment that protected tenants who entered the property before it became public premises. The Supreme Court said that was wrong law because a constitutional bench had already settled it way back in 1990 and clearly held that the Public Premises Act overrides rent control laws no matter when the tenancy began.
And what was the case that triggered this reference?
It involved LIC trying to evict a tenant from a Mumbai flat that was rented way back in the 1950s. The tenant argued that old rent laws still protected them. The Bombay High Court, relying on the earlier 2014 ruling of the Supreme Court, sided with the tenant and quashed the eviction order, prompting LIC to appeal to the Supreme Court. So this appeal first landed up before a bench with two judges. The bench noticed that there was a divergence of opinion, meaning simply that earlier benches had taken completely different views on the issue. This is why this two-judge bench decided to refer the matter to a larger bench. And this larger bench with three judges disagreed both with the Bombay High Court's decision and its own 2014 ruling and said once LIC terminated the tenancy, the occupation became unauthorized and the Public Premises Act kicks in.
Next, a quick but important update from the Delhi riots larger conspiracy case. The Supreme Court has now reserved its judgment on the bail pleas of Umar Khalid, Sharjeel Imam, Kulfisha Fatima and others. So Ostika, where does the case stand right now?
So Debojit, the Supreme Court has finished hearing all sides and reserved its verdict on whether these accused who've been in jail for over 5 years under the UAPA should be granted bail. The core defense argument was very simple. There's been massive delay, the trial hasn't even begun, and there's no proper or direct evidence of violence attributed to many of them.
And the prosecution stance is?
The Delhi police stuck to its case that this wasn't a spontaneous protest leading to violence, but in fact a planned conspiracy, what they called a pan-India plot involving speeches, meetings, WhatsApp groups, and funding. They argued that once conspiracy is alleged, everyone is legally linked, even if they weren't physically present at riot sites. Anyway, now we wait to see which side's arguments found favor with the bench of Justices Arvind Kumar and N.V. Anjaria.
And there's been a parallel development too, right?
Yes. While the Supreme Court reserved its judgment, a Delhi trial court has granted interim bail to Umar Khalid for a limited period between December 16 and 29 December so that he can attend his sister's wedding.
We also have an important development from the Bombay High Court connected to the Bhima Koregaon case and Father Stan Swamy. Just to set the context first, remind us, Ostika, who was Father Stan Swamy and what is the background here?
Father Stan Swamy was an 84-year-old Jesuit priest and a long-time tribal rights activist. He was arrested under the UAPA in October 2020 in the Bhima Koregaon Elgar Parishad case, making him the oldest accused in that case. He passed away in July 2021 due to cardiac arrest in a private hospital just days before his bail hearing.
Right, and the subsequent case was related to the allegations made in the course of the unfinished trial.
Right. After his death in December 2021, Father Fraser Mascarenhas, the former principal of St. Xavier's College, Mumbai, approached the Bombay High Court on behalf of the Jesuit community. The petition sought two things. First, to clear Father Stan Swamy's name in the Bhima Koregaon case, and second, a court-monitored judicial inquiry into the circumstances of his custodial death. At its core, the concern was quite simple. While denying him bail, the special NIA court had made strong observations that continue to brand him as guilty, even though he passed away without ever facing trial. The petition argued that this violated his right to dignity and reputation under Article 21, and that this stigma has followed him even after his death, affecting both his life's work and the Jesuit community more broadly.
So, how did the hearings go and what did the High Court decide this week?
The NIA raised a technical objection. It said that since Father Stan Swamy had passed away, the petition itself has become infructuous. The Bombay High Court accepted that objection and disposed of the petition. However, and this is important, the court gave liberty to file a fresh petition specifically challenging the magistrate's inquiry report into Father Stan Swamy's death.
Which really leaves us with a troubling question. If an under trial dies in custody, can unproven allegations continue to define their legacy forever?
Exactly, and there's another dimension here. This very petition filed back in December 2021 was listed nearly 8 times before 5 different division benches of the Bombay High Court. Judges heading 3 of these benches were accused from hearing the matter. Justice Prasanna Varale, who's now become a Supreme Court judge in February 2022, Justice Sadhana Jadhav in April 2022, and Justice Revati Mohite Dere in September 2024. Critics often point to this case when talking about how politically sensitive matters can place enormous pressure on the judiciary, something that ties back to the broader conversation we were having earlier about judicial independence and difficult matters.
Now, our final story for this week's episode. After nearly 8 years, the Ernakulam Sessions Court has finally delivered its verdict in the 2017 actress assault case, which relates to the abduction and sexual assault of a Malayalam actress in a moving vehicle on the outskirts of Kochi. Actor Dileep has been acquitted while 6 others, including prime accused Pulsar Soni, have been convicted and sentenced to 20 years in prison. Ostika, what stands out to you from this judgment?
What stands out is that the court has been very clear that the crime itself was proved. The abduction and sexual assault were established, which is why the main accused and others have been convicted. But when it came to actor Dileep, the court felt that the prosecution could not legally establish his role in the conspiracy beyond reasonable doubt, which is the standard in criminal cases. Another thing that stands out is that the court has reminded that it cannot be guided by public sentiments or the sensational nature of the case.
So, what's the next stage in the saga?
Honestly, Devojit, in a case like this, which is so high profile, so contested, appeals are almost inevitable, especially against the acquittal. If you remember, the survivor had herself approached the Kerala High Court more than once during the trial. In 2019, seeking that the case be heard by a woman judge, which was allowed, and in 2020, seeking a transfer from that judge on grounds of bias, which was refused by the High Court. So, like I said, it's been a highly contested case, so we'll have to wait and see how this plays out, but I do expect multiple appeals.
And that's a wrap on the major courtroom developments from the last week. We'll continue to follow these cases closely and break down what lies ahead with Advocate Ostika Das here. Thanks for watching Courts This Week by LiveLaw. See you next time.